Hello and welcome to BloombergQuint. You're watching the fine print and news just coming in that the Gujarat High Court has dismissed the Essar Steel petition that had alleged that the RBI's criteria for picking up 12 companies for the IBC process is arbitrary. The Gujarat High Court has dismissed this allegation by Essar Steel, and to understand the implications of that, I have with me Anand, Desai, partner at DSK Legal. But before that, let me take you to Vishwanath Nair, who's here with us to give us a little background on what actually happened at the Gujarat High Court and what was Essar's contention to begin with. Vishwanath, you've been following this case very closely. Give me a brief of, and for the benefit of our viewers, why was Essar Steel before Gujarat High Court? Because the SBI, the two lenders, SBI and Standard Chartered, had already filed petitions before NCLT bench of the, at the Ahmedabad.
That's right. So, as we understand it, SBI and Stancy had filed a petition each at the NCLT in Ahmedabad for an IBC proceeding against the company. But the company has objected to the RBI's decision to list it as part of these 12 accounts, 12 large accounts which have to be immediately put under IBC. The company claims that this is against their fundamental rights and that the RBI's decision-making process was probably arbitrary. Now, if you remember, the RBI had a clear criterion laid out to select these 12 cases. They said that any account with a banking exposure of 5,000 crore and above can be selected, and of this exposure, about 60% had to have turned NPA as on 31st of March 2016. Essar has said that 2016 is a very arbitrary date because since then we have paid back banks quite a bit of money. So you have to take that into account. And they had also said,
I think, that they had a restructuring
exactly.
plan
So
in place.
that restructuring plan has been in place for many months now. That's what Essar is claiming, that this was something that the bankers had agreed to and that we were in the process of implementing it. But before that, the banks have gone ahead and filed an insolvency proceeding against the company. So.
Sure. Mr. Desai, welcome to the show. Did you see Essar's move to go to the High Court as a stalling tactic?
I wouldn't call it stalling. I think they were trying their, I shouldn't call it luck, but trying to test whether the principles applied by RBI were sustainable or not.
Okay.
Which is not unusual in India, because if they feel a certain set of circumstances exists, they have a right to at least ask the court to look into it and decide whether what RBI is saying is right or what they are saying is right.
But if you're contesting that, we have a restructuring plan in place, at least you will, you'd want the bankers to back you up, right? Because in this case, even SBI was arguing, if I'm not mistaken, against Essar's allegations.
That's right.
So I think what worries companies is when you're with the NCLT in a proceeding under the IBC, the professional takes over, insolvency professional, he takes over, so to speak, the entire management. He can replace management, he can bring in people, bring in others to finance it. Which from a management's point of view obviously restricts their discretion as to how they want to run their company or restructure their company. I think that's going to be the controversial provision when companies feel, or the management feels, that we can turn it around, we can run it, give us some time. Versus a professional coming in who's really an outsider. He's not been part of the system. He doesn't really understand the business necessarily as well as the promoters. I think that's where the stress is going to be in all these situations as to how do you now take this process
But
forward.
that's the law. It's high time, companies
That's
sort
right,
of accept it and reconcile
it's
to that.
something which obviously doesn't go down easily. If
Sure.
Earlier your liquidator came in as a provisional liquidator first, then a final liquidator, the management still continued.
Yeah, it went
That's
like
a big
a 5-year plan of sorts of. So
That's a huge change.
while the Gujarat High Court has passed this order now, while it will have a persuasive value for rest of the states, do you still believe that companies who are part of the list of 12 would want to try their luck at different high courts, or do you see merit in any of the arguments that Essar had placed?
I think if the restructuring does happen, the management comes back. It's not like the management is gone forever. It's really a situation where, so to speak, banks' funds, public funds are at risk. I think the IBC intends to look at that system and see if this company can come back to operating profits or is heading the wrong direction. It could be a change in technology, for example. The company could be redundant in terms of what its business is. So I think all this needs to be looked at carefully. And as we know, the amount of loans has just been so large.
That's right.
And the defaults have been so large that something was considered appropriate to be done, and that's what the law is.
Sure, and one of the worries that at least these 12 companies had was that the operational creditors, the vendors, once the IBC process kicks in, it's going to impact that relationship as well.
So like I said, they are defaulters to start with. Let's accept that.
No, so I'm asking what happens in the interim once IBC process kicks in.
So the company runs.
Right.
It's not like the entire company is stripped of all assets and all personnel. The company still runs. There's, like I said, a concept of a professional who comes in. He can have advisors. It could be lawyers, accountants, management personnel. It's not different to international models in many countries. So it's not something unique India's come up with. It's new for India. I think the way of doing business in many countries is different from each other. But to answer your question, I think it's going to pan out in a certain way. But I can't see a blanket, everyone can challenge and somebody may win. I can't see that happening.
Okay, do you still see that Essar might want to appeal this order
Possibly.
in any fashion?
Possibly.
So it will go to the NCLAT?
Well, they can either go to NCLT and say that this proceeding is incorrectly filed,
Right,
charge sign failed. It could go to appeal from the High Court order,
right.
in which case they'll be tested again.
Okay, and they will file the order in the appeal in the Supreme Court then?
I think it'll go to a division bench. I'm
Okay.
not very sure.
Okay, this was a
Yes,
single judge
this was
bench.
single judge bench.
Okay,
that's
so
right.
then it will go to a division
And
bench.
then to Supreme Court.
Okay, outside of Essar, let me also talk to, and Vishy weigh in on it.
Yeah.
There are certain cases where before the IBC process or the sort of that avatar of the NCLT came into being, there were several winding up petitions, for instance, Alok Industries
That's right.
and
Alok
Era.
Industries and Era Infra, these are the two
Right.
big companies
where
where
lenders had, or some set of creditors
Yes.
had already filed winding up petitions. What happens to those cases?
So winding up jurisdiction is also now gone to NCLT.
Sure.
So they'll move there and probably be considered as one big package because the relief can't be contradictory.
Sure, and also, I mean, in those cases, will the lenders have to file a fresh a petition before the
They'll
NCLT?
join in this petition, in all likelihood. They'll
Okay.
be heard in this petition.
those creditors become part of this.
I would
as
imagine so.
Okay,
Because
okay.
the cause of action is similar.
Right.
The default, there's a company that owes money and you're asking for the money.
Okay, outside of Essar case and Alok and Era, let me also ask you to weigh in on where do you see the process now facing the maximum challenge, right? This was the hurdle one where the rest 11 were waiting to see, look, if Essar gets some sort of relief, that might translate into their deadlines also getting delayed in some fashion and they also getting similar relief. Where do you see the next step of challenge in this process?
Well, somebody may go to a High Court again, as you said earlier. But I think the big change is also we've had a series of attempts to restructure. For years we've had the Sikh Industrial Companies Act from like 85. We had SARFAESI. We've had various schemes of RBI of informal restructuring, formal restructuring. Somewhere I think the realization came that all these had a role. It was not really a composite role. And that's why this act has come into force. And I think this law is really implemented effectively. There's enough meat in it, teeth in it, and yet opportunity to look at the whole situation and decide which way the company should go. So I think all the players have a right to be heard. There'll be a deciding authority. The lenders will have a big role to play, obviously, because that's the largest chunk. I think overall it's a healthy situation. You can't let, so to speak, Sikh companies live forever. The old the Sikh Industrial Companies Act had a section 22 which brought a stay, a moratorium. That's not automatic.
Right.
So I think there are many factors which will play out. But to answer your question, I think some may try, some may not try.
No,
We're
I'm
not the
saying
only
so
12.
that is, I'm
Because
saying.
don't look at this only 12 companies. There are
No,
many
of course
in that
not.
area.
Of course not. I mean, I'm saying from the RBI's selection criteria for point of view. Immediate selection rather from the point of view. I don't know, Vishwanath, if any more are coming or are in the offing.
According to what sources have told us, there are other cases being looked at right now. But however, we are still waiting to see what happens to these 12 before the banks decide on what they want to do in other smaller cases going ahead.
Sure. Okay. Mr. Desai, I want to come back to my point on challenges and get a word from you on that, okay, case gets admitted, the NCLT decides whether, restructuring is an option or it needs to go to insolvency. And I think if the 180 the day timeline expires, it automatically anyway goes into the insolvency process. At that stage when, a temporary IP is appointed and then finally when the committee of creditors sits, a final IP is appointed. At that time, do you see scope for private M&A deals or is there going to be
financing deals, private M&A deals, all of them are possible.
You don't see that it would be necessarily an auction route that the committee of creditors will have to take?
Not necessarily. So the first attempt will be to get in private financiers. or a takeover.
Okay.
If that can't happen, there may be some breaking up, separating.
No,
selling.
I'm talking because these are some of them are PSU banks, and that they have the maximum exposure.
Right.
Can somebody get in and say that, look, you didn't cut the best deal, and there was a better deal possible? Why didn't you go the auction way?
So that's where the IP and the NCLT comes in. So the lender is not free to do exactly what they want. So the IP is not an agent of the lenders.
I see.
The IP is actually an independent professional who's supposed to be running the entire process. And that's important to understand. I know a lot of people have registered as IPs, not being very clear what the role is. But the role
But
is
just for an employment opportunity.
well.
I mean, there is an there's
it's
an opportunity,
I
right?
think it's a very tough job.
Of course it is.
I know I've
And
heard of some who waited for instructions from lenders, and the lender said, "Sorry, we are not here to instruct you.
right,
It's your job to do what you are
How to
doing.
go about it.
It's our job to do what we are doing."
sure.
So I think many of the IPs who have registered may not have understood what they're getting into. It's a significant role to be an IP in a company of this size, such as Essar and others. So that we have to wait and see. But to answer your question, the lenders can't be blamed for things because the IP is the guy running it, not the lender.
Mr. Desai, let me also put in this question. The RBI has come out with a set of guidelines on how to provide for these assets which go to the insolvency court. Do you think that will become a sort of an impediment when banks are deciding on what to do in these cases, because they don't seem to be too enthused about setting aside 50% of the exposure as provisions whenever they come to
And
these
that's
cases?
what deterred banks all along on the valuations front,
Exactly,
right? To
exactly.
actually do something about these assets.
But some should have done it long ago anyway. It's not like every case is happening now because it should not have happened earlier.
Correct.
Right.
So you're right. I don't think the act is there to make people happy or to make them comfortable. I think it's a transition phase currently, so there's lots of anxiety and uncertainty. We'll play it out. I don't see that.
But
as a big
even in companies, cases where companies have said that there was already a restructuring plan, that plan can actually come into effect even under this process, right? I mean, that it doesn't go away.
issue. No, absolutely. Except through the IP.
Yeah, through the IP, of course,
Yeah.
yes.
All right, Mr. Desai, thank you for joining us for your first quick take, but we will come back to you once the Gujarat High Court order is out, and please stay tuned to BloombergQuint.com. And I don't know why people are clapping behind me in the background, so let me say bye to you and go and find out why the newsroom is clapping. Thank you for joining us
Thank
on
you, guys.
BloombergQuint.
Thank you.